Good afternoon, everybody. I'm Jeannie Allen. It is Wednesday, and it is time to talk about Espinoza and making the most for states of this historic Supreme Court decision. I'm so happy that you've all joined us today. We have a fast, furious, and insightful panel that we're going to get to in just a minute. But I just want to give you a little context. I'm going to actually ask my CER team maybe to come up with a little poll midway through about how many of you have heard about Espinoza and Blaine amendments, kind of where your knowledge base is right now. But in case you didn't know that 37 state constitutions had these pernicious things called Blaine amendments, named after a 19th century guy named James G. Blaine of the Know Nothing Party, that was started really in reaction, sounds so familiar today, at odds with immigrants coming into this country, in particular Catholic immigrants from Ireland. It's kind of odd that in 2021, we'd be talking about such an issue, but in 2020, the Supreme Court did rule and affirm the right of parents to ignore that and direct the education of their children. I know our first guest in particular will put that in a little bit more serious legal terms. But for those of us who are most concerned about everyone in the nation and in our world getting education opportunity and not being confined by redlining and zip code to where they go to school, or choices that were made more than 150 years ago for us, this is an exciting time to be educated about Espinoza and be educated about education opportunity. As the Institute for Justice said during the proceedings, while this ruling effectively invalidates nearly every Blaine amendment, there is much more to be done to ensure the ruling is enforced, specifically by wiping bad case law off the books and establishing programs that codify parental choice in every state. So here's what we're going to do. We're going to have four people. Each of them is going to speak for a few minutes. I'm going to bring them back for a panel. Would love your questions posted in the Q&A. And please don't forget, whatever you do, to check out our new Blaine page, our new page about Espinoza. Choice is constitutional at edreform.com, edreform.com/choice is constitutional. Should be super simple. And for those of you who are not with us on this particular issue and who take umbrage on that, game on. Let's take it to the states and take it to the court. So without further ado, I want to introduce our first guest and a dear friend, someone who helped shepherd school choice cases through the courts over the years. He has more than 100 Supreme Court cases he's argued to his name. Paul Clement is a partner in the DC office of Kirkland and Ellis. He was the 43rd Solicitor General in the U.S. from June 2005 to 2008. And he helped author, he actually led the authoring of the analysis that we sponsored with support from Excel and Ed that takes states and advocates through what it takes to remove the barriers. So, Paul, let me bring you on right now to kick us off. And after Paul, we'll go to David Hodges from the Institute of Justice, and Pam Benigno from Colorado, and Ross Izard from ACE Scholarships. Paul, welcome. Why don't we, would love to invite you to start, correct anything I said that was wrong, which you have to do on a regular basis, and really kind of set up what's at stake with this decision.
Okay, Jeannie, it's great to be with you. Looks like my little logo is backwards. Nothing I can do about that now, but hopefully it's the only thing that's backwards.
You're good.
Okay, good. So just to set the stage for this, the Espinoza case is a really big deal. And I think, that's obviously doesn't sound very legal, but for those of us that watch the Supreme Court decides about 70 cases a term, but each term it decides just one or two decisions that are really transformative. And Espinoza was one of those decisions from last term. And just to give you a little perspective on how transformative the Espinoza decision is, when I first started litigating religious liberty issues about 25 years ago in the context of the Wisconsin school choice program, the big issue was whether it was permissible under the federal constitution to include religious schools in a choice program. And indeed, the very first version of the Wisconsin school choice program, the pilot program, was limited to non-sectarian private schools. They were the only ones that could participate. And the Attorney General of the state of Wisconsin defended that statute on the grounds that the limitation to non-sectarian schools was actually constitutionally necessary, that it would violate the Constitution to include religious schools in the program. And later the program was expanded, and it's the very fact that the Attorney General took that position that allowed Governor Thompson to hire private counsel. And that's how I first got involved in these cases. But that was the first great struggle to get religious schools included. And fast forward to the Espinoza case, and the Supreme Court then decides that not only does the federal Constitution allow the inclusion of religious schools and choice programs, but it essentially compels it. That if a state wants to have a choice program and wants to include non-sectarian schools in that program, it cannot constitutionally, under the federal Constitution and principally the Free Exercise Clause, but as supported by the Equal Protection Clause, the state has to include religious schools in that program. So as a result, there's really been this complete transformation. And I think people are still in the process of appreciating just what a transformative change there is. Because at the same time that a state like Wisconsin, through its state Supreme Court, upheld the Wisconsin school choice program, and then the Supreme Court, in the context of the Ohio school choice program in Zellman, upheld the constitutionality of its program on federal grounds, there were still state courts that were invalidating these same provisions on the basis of their state constitutional provisions, the state Blaine amendments that Jeannie was alluding to. And Espinoza brings an end to that. Espinoza says that you cannot use a Blaine amendment, and I think it stands for a broader proposition that you can't use essentially state law, whether it's a Blaine amendment or something else, to exclude religious schools from a program that you allow non-religious schools to participate in. It's a real equal participation, equal treatment guarantee on the federal constitutional level. And I think that there are kind of two ways of thinking about the case, and both ways are incredibly important. The first is the holding that I've just described, which is state law can no longer provide an obstacle to the participation of religious schools in a program that the state has opened up to non-sectarian schools or private schools that are not religious in character. And so because of that, old decisions from state Supreme Courts that used their own Blaine amendments to strike down school choice programs or other programs on the ground that, sure, this is permissible under the federal Constitution, but our state constitution is more restrictive. So therefore, this is unconstitutional as a matter of our state constitution. Those cases are no longer good law. And there are some arguments that can be made to try to distinguish the Espinoza case. And I think David in a minute will mention kind of one or two of the arguments that are out there. But I don't think those arguments really stand much of a chance with the current court. So if you have cases that are essentially on all fours with Espinoza, I think there's no question that excluding religious schools under those circumstances is not going to pass muster. It's just unconstitutional. But the second thing that I think is important, and this is really alluded to in Justice Alito's concurring opinion, but the whole notion that these Blaine amendments should even remain on the books is called into question, because as Jeannie alluded to, these are not sort of wholesome provisions in the federal constitution or state constitutions that should be looked at just like any other provision. These are provisions that are only in the state constitutions because of discrimination on the basis of religion, and they're being used in the present day, over 100 years later, to discriminate on that same basis, on religion. And that's just something that really shouldn't have a place in our current discussion. And I think over time, again, if this issue gets back to the Supreme Court will only fortify that analysis. Now, the last thing I'll say before turning it over is the most obvious cases for applying Espinoza are those cases where a state has a program and it allows private non-religious schools to participate, and it excludes religious private schools on the ground that something in state law requires them to make that distinction. I think those cases are effectively directly controlled by Espinoza. But even if the state tries to, under certain circumstances, prevent all aid to all private schools, if it's doing so based on a similar motivation, and this is one of the teachings of the Espinoza case because of the way it came up through the system, but it's not enough for a state to say, well, if we allow private schools to participate, we'll have to allow the religious schools to participate, and we don't want the religious schools to participate, so nobody gets to participate. That's still discrimination on the basis of religion, and I think that's still prohibited by the Espinoza case. Now, that's something that will require, I think, some litigation. That's maybe not the absolute core of the Espinoza decision, but I think that's implicit in the Espinoza decision as well. So to sum it up, the Espinoza decision, I think, provides proponents of choice in education a powerful tool, both in the courts and in the state legislatures. And to the extent that in the past, people have an opposing choice, have pointed to these state constitutional provisions, that all these issues are ripe for reconsideration and teeing up with that sort of state constitutional canard off the table. So with Jeannie, I'll turn it back and kick it over to David.
Thanks so much, Paul. Before you go, and if you've just joined us, you have been looking at Paul Clement from Kirkland Ellis, former Solicitor General. You wrote the roadmap, Making the Most of Espinoza, and we will put the link for our participants in the chat area. But can you just kind of sum up real quickly, what's the difference between the level of activity or energy that states and advocates can spend on this now versus before? I mean, you kind of lay out a couple of ways to make sure those barriers are removed. There's already a question about what the impact is at the state level. But I think if I'm correct, you really use that analysis to say you can aggressively really go after if these things are on your books because specifically they were there to discriminate.
Yeah, no, I think that's absolutely right. And as I suggested, there's sort of two routes here. There's the route that sort of goes through a particular educational program, and to the extent that in the past that's been either invalidated or opposed on the grounds of the state constitutional provisions, all of that should be reopened and revisited because those constitutional arguments are no longer valid. But as you suggest, another route here is to go directly at these Blaine amendments that are still on the books. They don't belong there. They are a product of discrimination. They are being used over 100 years later to discriminate. And so whether it's efforts in the legislature to repeal them, whether there are efforts in the context of ongoing litigation to essentially get the state courts to recognize that those provisions are constitutionally infirm, or whether it's eventually to get this teed up for the Supreme Court of the United States. But I do think, reading between the lines of those decisions, the Espinoza decision came down before Judge Barrett joined the court. I think that, provides just additional impetus to getting this issue up there and taking on those amendments head on.
Terrific, Paul. Thank you so much. We will see you in a little bit for our panel. Now I am so pleased to bring on David Hodges, who, for your context, was part of the legal team for the Institute of Justice that filed the Espinoza case in 2015 and fought long and hard for 5 years to the final victory that we're discussing today. Pretty extraordinary, David. And when you start talking, I would love to know kind of what that felt like, not only being accepted in the court, but being walking in that day. Many of us were there cheering you on. David, over his tenure, has worked worked with many programs and advised states and policymakers as well as lawyers on education law. He's been interviewed widely throughout the media, and we are just so delighted to have you with us today.
Sure. Well, thank you very much for having me, CER. It's an honor to be part of this distinguished panel. Yeah, to answer your question, Jeannie, it was an incredible day walking up to the Supreme Court. We had worked on that case for probably about a year. I think we had probably asked our attorney who was arguing it probably over 1,000 questions and variations of those questions, just trying to think through every single way that the justices could approach us. And when we walked out of the court, I think all of us were feeling cautiously optimistic that this kind of constitutional vandalism known as the Blaine Amendment was seeing its last days. So I'd like to talk about two things. The first is the legal challenge after Espinoza, and the second is legislation in the states after Espinoza. So in the Espinoza decision, as Paul alluded to, there was something that we like to call the status use distinction. So basically, when Justice Roberts wrote the decision, he basically said, you can't discriminate based off of religious status, and he left the question of discrimination based off of religious use for a future case. And when he made that decision, he basically said that even though the Espinoza decision was based on status, that nothing should suggest that use would be judged differently. Now, to a lot of people, including Justices Breyer and Justice Gorsuch, the distinction between religious status and religious use is basically a distinction without a difference. For example, what does it mean to not be discriminated against because you're Jewish, but to be discriminated against because you do Jewish things or whatever faith tradition that one belongs to? But at the same time, in the Espinoza decision, they pretty much put the writing on the wall that status discrimination was unconstitutional and use discrimination was also likely unconstitutional. However, in the first decision from a federal court that came down after the Espinoza decision called Carson v. Macon in the First Circuit, the court was considering basically what's called a sectarian exclusion in a statutory program in Maine. And basically what it did was it provided school choice to everyone unless someone was attending a sectarian school. And the First Circuit, looking at the Espinoza decision, said, well, Espinoza banned status discrimination. So status discrimination is unconstitutional, but the sectarian exclusion, well, that's use discrimination, and that can be judged differently on a much more lenient standard. Needless to say, we think that this, like Justice Gorsuch, that this is a distinction without a difference, and that the Supreme Court, implicitly said that use discrimination is just as abhorrent as status discrimination. And next week, the Supreme Court will be considering the appeal that IJ filed in the Carson case, and they're going to be talking about it at their conference. And we have our fingers crossed that they will take the case up just as they did with Espinoza, and come to the same conclusion that we've come to, that status and use discrimination are both equally abhorrent. So our view right now is that legally, Blaine is almost dead, like the Monty Python skit, but it just needs one final thrust for it to be fully dead. Turning over to the legislatures, after Espinoza came down, we were cautiously optimistic that this was going to be a good few years in the legislatures. So when I was speaking with my colleague before the legislative session began, he said, how many states do you think are going to pass school choice legislation? And I didn't want to oversell things, so I said, I don't know, maybe 6. And he said, really? He said, normally we think of a good year as being maybe 1 or 2 programs. So right now it's June 16th, and this year there have been 14 states that have passed programs, and it seems like there are 2 more on the way, New Hampshire and Pennsylvania. So it's 14 states. They've passed a total of 19 programs. 5 of them are brand new, and 14 are expansions of existing programs. So how did this happen? I think that there were two things that went into it. First is Espinoza, and the second is the pandemic. Espinoza removed the biggest constitutional obstacle facing legislators. We'd often talk to legislators and they say, hey, we'd love to help you, but we don't want to invest all this political capital into passing a school choice program and then have it struck down by the courts. Well, once Espinoza was taken away, they could no longer, use that excuse. The second thing is that the pandemic exposed the bad faith of, many teachers unions. There was a dynamic in a lot of states, not every state, but a lot of states, where private schools moved mountains to educate, while many unions moved mountains so they wouldn't have to educate. And I think to a lot of people, not just on the ground, but a lot of legislators, it really showed the need for choice. And I'll close with just giving two examples of states that we worked in for a long time. The first was West Virginia. Last year, it was the state that I think ranked 49th in the nation for school choice. And just a couple months ago, they passed a far-reaching school choice program. So now they're number one in the nation for school choice. And that was the result of a lot of work from a lot of people, including at IJ. The second state was Kentucky, and that was a state where there was also a lot of opposition, a lot of reticence, a lot of uncertainty about how Blaine would apply. And we spoke to a lot of legislators and just reassured them, hey, Espinoza has changed the rules of the game, and now you should be able to pass a school choice program in the state. And a couple months ago, they did. The first school choice program that they've had in the state's history. So just to sum up, Espinoza really changed the game. Legally, there's still a little bit of work to do, but legislatively, there are a lot of programs that are on the table that were not there just a couple of years ago.
David, that's terrific. Thank you so much, David Hodges, Institute for Justice. And, as you're talking about the legislative track that we've seen over the last several months, I'm also remembering how much, because I'm thinking, okay, yes, the pandemic, but also Espinoza. They always say when God has a really good time, he has a really good time, a great sense of humor. But I remember, not to date myself, 30 years ago, states talking about education choice and saying, oh, we can't do it. Even in friendly territory, meaning people who liked it, both Democrats and Republicans, by the way, we can't do it because of the Constitution. And they'd always say that. I mean, Pennsylvania Governor Tom Ridge in 1991, moderate Republican with lots of different kinds of people in the legislature, said, I'd love to do it, but I'm told that it's against our Constitution. So do you think having, sort of that out of the way is people are aware of that, or do you think they're just becoming aware of that?
Yeah, I think that they're still becoming aware of it. When Espinoza came down, there were a lot of other decisions that were in the news. I think that was around the time that the Bostock decision came down, also the transgender one. So a lot of people were talking about that at the time. But as time has gone on, people have become more and more aware that essentially a new legal regime is in town. It's been building up for a long time. The writing has been on the wall, I think probably ever since the Trinity Lutheran decision of 2017. But people still need to be educated about it. And when we go to state legislators, there are some that say, hey, I know all about Espinoza, but there are others that we need to talk to them a little bit about it and tell them about how things have changed and about how the doors are essentially wide open for them to pass a school choice program and to not worry about their Blaine amendments and about other anti-religious constitutional amendments that are rooted in anti-Catholic bigotry.
Yeah, and it means we can have a discussion on the merits, right? And so wherever you fall down, it's a lot more equitable. David, thank you so much. We'll bring you back in a little bit. And while I'm bringing on Pam, if we can queue up that cool little poll, would be awesome. So please just let us know how aware you've been. Maybe you all know what's been going on, but would love for you to just take our little poll that you're seeing on the screen right now. Okay, so Pam, you are next up. Pam Benigno is director of the Education Policy Center at the Independence Institute. Pam has served on various committees, including the Colorado State Board of Education's Implementation committee for a school voucher program that was struck down by the Supreme Court. She has spearheaded efforts to expand parental choice in Colorado via a tax credit. And she's just a tireless advocate. And one of the reasons beyond her years of experience in this arena that we really wanted Pam to join us today is because she's been there when two programs in Colorado were declared unconstitutional. And so we'd love your insights, like what's going on in, as we like to say, the real world. And please, again, everybody, cue in your new questions and everything else. And we will be bringing the panel back shortly. But let's hear from Pam about your experience, and then we'll go from there. Thank you so much, Pam, for joining us.
Oh, thank you, Jeannie. It's an honor to be here. And everybody, welcome to my home. I have an old device that will not support background. So I'll buy a new computer next week, right? Thank you so much. Yes, Colorado has tried many times to have a school choice program, but the two programs that actually were adopted, I'd like to tell you a little bit about, because in your state, just the same in Colorado, thousands of kids, and this is really what it's all about, are the kids that need an equal opportunity. They need an education that fits them best, and that's why we all work so hard for this. And back in 2003 in Colorado, Black leaders, Hispanic leaders, all got behind, and white folks too, all got behind then Representative Nancy Spence and her school voucher bill. The bill passed. Governor Owen signed the bill. We had a great celebration on the Capitol steps with private school children dancing and singing. Great celebration. Unfortunately, like usually, there was a lawsuit filed. So we waited and waited, and they finally filed the lawsuit, and the judge put a halt. He enjoined the program, so we couldn't continue working on implementing it. The opponent's attorneys asked the court to expedite there were Blaine issues that were part of the lawsuit, but the attorneys asked to please expedite and hear first two Colorado issues in our state constitution that would not go up to federal court. Well, we won on one and lost on the other. And it was so disappointing because we really hoped that, and IJ was involved as, they're helping families intervene. And we hoped that this would be the case that would go to the US Supreme Court and that would settle this Blaine debate. But because our state constitution gives our local school board members authority over school finances and school instruction, our courts struck the program down on local control. Well, that inspired the Douglas County School Board, which is the south metro area in Denver, in 2010 to start a school choice task force. And they brought in community members, and they said, how can we better serve your kids by expanding choice in Douglas County? Well, one of the subcommittees said that they wanted a voucher program. And this board was so bold and so confident. They said, well, we believe we have the best schools in the state, but we know we can't meet everybody's needs. So we will adopt a school voucher program. And they did in 2011. Well, like expected, there was a lawsuit. The program was halted. Unfortunately, the judge came out with a decision on a Friday afternoon about 3:30. And kids like Nate Oakley, who has autism, was starting his new school on Monday morning, and he didn't get to go. It was heartbreaking. It was very, very sad and disappointing to so many families and children. So that case went up through the courts. Now, I'm not an attorney, but I'm going to try to explain to you what happened. So as it went up through the Colorado courts, we lost at the Colorado Supreme Court, and our side appealed to the US Supreme Court. David mentioned Trinity Lutheran. Well, in June of 2017, the US Supreme Court came out with the Trinity Lutheran decision. And that was about tire scraps for a Lutheran preschool. They just wanted to, have a new playground surface. And so the US Supreme Court said, their Blaine amendments can't stop that. So the next day, the U.S. Supreme Court, they took the case, the Douglas County case, but they weren't going to go through the hearing process. They vacated the Colorado Supreme Court decision and told the Colorado Supreme Court to reconsider this case under their decision in light of Trinity Lutheran. Well, over the years, this Douglas County case was adopted in 2011. Well, over the years, the teachers union came in and they started picking off the school board members. And so now we're in 2017, school board election year. November, I said the decision was in June. November, the teachers union totally took over the Douglas County School Board. It was, we were in the fight, tried hard, but lost. They took it over. The Colorado Supreme Court had held off on making any decisions. So then at the very first school board meeting in December, the very first item on the agenda was to end the Douglas County program, the scholarship program, and they did. And they ordered the school district to stop any litigation. And so, therefore, and we had not heard from the Colorado Supreme Court yet, but, eventually they said, this is a moot point, and the program was over. I really believe that, the path has been cleared for Colorado. And I'm hoping that future policymakers, whether they be school board members or legislators, will get over, listening to the teachers union, and that they're really going to decide and feel in their heart, we really want to do what's best for kids. So I'm hopeful for Colorado in the future. Thank you.
Thank you so much, Pam. Really appreciate it. And we'll talk a little bit when you come back about, what people can do who might be interested. But I think it's just fascinating context for people to understand. If they're not in Colorado, they may not have had any idea that was such a big issue, and kind of the overturn, because it is politics, policy, and law. So it's what we're all involved in. So thank you so much. And finally, last but not least, I want to bring on Ross. Ross serves as Vice President of Policy and Government Affairs at ACE Scholarships. He has assisted with a number of the amicus briefs, both in Colorado and also advising on legal cases elsewhere. And at ACE, Ross works with a team there. If you're not familiar with it, they provide scholarships to low-income kids to pay tuition costs at K-12 private schools across the country. I think 8 states. Is that right, Ross?
Yep, that's right.
So we'd love to have your insights, kind of batting cleanup on what we missed, what you think is next, and then we'll get in discussion. And ladies and gentlemen, we'll take all of your questions. And thanks for taking the poll. We'll give you the results shortly. So Pam, thank you, and Ross, take it away.
Sure, thanks, Jeannie. And as far as batting cleanup, I think letting the smart people talk first is always a good plan. So I'll cover a few pieces here, mostly on the political side. So I'm sort of a strange species of animal. I've spent a fair amount of my life working on the legal and policy sides of Blaine amendments. So as Jeannie mentioned, I've helped write amicus briefs on it. I've worked on the legal side of it, both here in Colorado and then later in Montana. But my main gig, my sort of day job, is really working on the political side. So I think I heard Paul say early on that the Espinoza decision says effectively that states don't have to have a school choice program, but if they decide to have a school choice program, then they can't discriminate on the basis of religion. So I live very much on the deciding to have a school choice program side of the aisle. So with ACE, I handle all of their policy work, anything on the state legislative side, regulatory side, federal side, and really spend a lot of my time working in state legislatures and with lawmakers across the country in our 8 states. So David mentioned we had an incredible year this year, lots and lots of new programs passing everywhere. I'm happy to say that 3 of those states were ACE states, and we had a lot of fun working there. Those were Arkansas, Kansas, and Montana. And I would like to say that the Espinoza decision made a huge difference, and it did in some cases. So I agree that it removed the biggest impediment. And I think that a lot of times when we were having conversations with legislators, they would like to sort of hide underneath that rock, right? So you'd come to them and say, hey, you really need to look at either expanding this existing choice program or creating a new program. And they would sort of immediately say, oh, no, I can't do that. It's unconstitutional under our Blaine Amendment. So we removed that rock, which was huge and I think was very helpful in a lot of the committee hearings and a lot of the work that we did. but it was sort of necessary and not sufficient, if that makes sense, right? So once we moved that rock, they all started scurrying to different rocks. And at that point, you're really sort of just doing politics the way that you always do politics, right? So politics is always politics. These conversations often look the same across state legislatures. And so it was awesome to take that big arrow out of their quiver and get rid of sort of the immediate cancel that you would get. But then inside of that, there was a lot of work that actually went into getting those legislative bills across the finish line, both in our states and elsewhere. And I'll keep my remarks fairly brief because I know we've been talking for a while and people would probably like to get to questions. But I guess the biggest thing that I would like people to take away here is that as huge as the Espinoza win was, and it was massive, so huge kudos to Paul and to IJ and to everybody else who actually litigated that thing. It is not enough to get kids what they need, right? And so one thing that we did see in the wake of Espinoza was a level of folks sort of dusting off their hands and saying, okay, we're done here. The Blaine amendments are dead, school choice for everybody, and we're good. We can move on. And that's not exactly true, right? So while it's helpful for those of us who are lobbying to be in there and to be able to take that leg of the stool, so to speak, away, there's still a ton of work to do. And I think that's true both for the organizations who are on the call here, as well as the people who are listening in and parents and schools themselves. There's a lot of work to do there, and there's not a lot of room for us to be complacent. So we've had a really good year here on the backside of the pandemic. I know we're all incredibly excited to see how much help gets out the door to real kids. I also know that there's a lot more that we're going to have to do, and that we are going to have to spend a lot of time thinking through both the ramifications and the implications of Espinoza. And also, really from a strategic perspective, how now that that barrier has been removed, we can drive these conversations forward in a productive way, not just this year, but in the future. So I'd be happy to talk more about the political side of it. But with that, I will wrap up and we can get into questions, Jeannie.
Russ, thank you so much. Let's bring everybody else back on. And I just want to say thank you for kind of pointing that out as well, that there's a lot to be done. And part of it is education, right? Part of it is the debate, having that public debate. Again, that was not prohibited, but was more difficult when everybody thought it was simply unconstitutional. Let's get Paul back in here too, if we can. So let me go ahead and just start with a question. And I'd love you all to also think about what wasn't said that you kind of wanted to say, but I want to be respectful of them. I'm going to go backwards. We've got a bunch of folks from Colorado. Well done, Pam and Ross. Here in Colorado, Representative Pico is asking, what legislation can I introduce to reverse this problem? And recognizing there's a hard majority in opposition. So I guess the answer would be any kind, right? I mean, for a while, everyone was kind of going the back door, trying to figure out ways that they could do things that wouldn't be unconstitutional. But is it as simple as a regular old voucher bill, Pam?
Oh, wow. Well, in Colorado right now, a voucher bill would be sent to the Kill Committee. So it's really up to local school boards. It's, we've already proven it can be done here, but so we just need another school board that will be bold enough and go that route. And like I said, I'm hoping that future legislators, younger people who aren't so tied to the union, are going to really stand up for education for all kids.
Okay.
And I think that the pandemic has shown a lot of parents because they were listening on the other side, of the computer.
Yeah, no. So for now, it sounds like the local school board might be the route, but again, that kind of depends on political wins. Terrific. Right. Thank you so much. Paul, I wonder if you can address the question from Mr. Hughes. What were the main differences in the Espinoza holding compared to Trinity Lutheran? What did Espinoza have Trinity Lutheran did not have, so that states were given the green light? And maybe Zellman plays into that somewhere.
Well, yeah, so I think in some ways the simplest way to try to answer that question is in terms of the legal theory that the court embraced. There's not that much of a delta between Trinity Lutheran and Espinoza. But Trinity Lutheran was kind of famous for having a footnote in the majority opinion that, essentially suggested that, this is a case about playgrounds and recycled tires on playgrounds, and don't think it really has anything to do with anything else. And I think that was, in there largely to keep the majority of the court together. And so I think everybody was kind of thinking, well, if Trinity Lutheran means what it says in most of the opinion, it's a huge decision. But if it only means what the court said it only meant in that footnote, then it's kind of a historical footnote, so to speak, and nothing more. And what Espinoza does is it really unlocks that and says, no, it wasn't just about playgrounds. It's about the most important issues that we care about, which is educating our children. And the theory that you just can't discriminate on the basis of religion and then say, well, my state constitution made me do it. And that argument is, I think, interred by the Espinoza case once and for all. And then where I think the kind of open threads of the decision are really, some of the, sort of the questions that David alluded to about sort of, status versus your broader beliefs. Another issue that I think is out there is, all right, does this extend to some of the more sort of esoteric state amendments that are a little bit different from the classic Blaine Amendment? And then the third question is really, what about Blaine? I mean, the court majority said a lot of, things that suggest that Blaine amendments have no place in any state constitution. Justice Alito went, full on and essentially said as much. And so there's every reason to think that those arguments will be accepted when that's squarely teed up for the Supreme Court. And I guess the one thing I would say is, in addition to, I'll leave it to Ross and others who are more expert on the political side of things. But I will say, I'd love to get somebody to try to defend their state Blaine amendment, because I just don't know really what you say in defense of those amendments, both in terms of their origins and what they are doing today. It seems like those are, a product of the aptly named Know Nothing Party, and they just really are very hard for anybody to defend these days.
Anybody else? Thank you so much. Anybody else want to address any of that? Or we can go on to the next question. I think one of the most interesting things, and you alluding to Justice Alito, Paul, that you taught us was when you were looking at the different opinions, the consenting opinions, there's so much richness in there that does point to and guide us in the future as well. A lot of people just look at the decision, go, okay, it's the decision, that's it. But Alito and many of the others really attacked the existence of the Blaine Amendment in many different ways. David, do you want to go ahead? Sorry, Ross.
Oh, I'm sorry. I was going to add just one thing there. So it's interesting that Paul brings that up about them defending the Blaine amendments, and I agree they're almost indefensible at this stage. So you've kind of seen people take a step back, and I don't know if they've totally abandoned the line of the false line of separation between church and state, but they've certainly taken a big step back there. Instead, what they've done, though, is kind of what Pam alluded to earlier, which is that they have really spent a lot of time fortifying their political abilities, right? So rather than sort of standing on the legal and philosophical ground of separation of church and state and Blaine amendments, what they've really done is turn toward, in Colorado, chambers where they have very, very deep anti-school choice majorities, or building out political structures around these efforts where if they can't win on finesse with legal and philosophical arguments, they'll try to win on brute force. So they may not try to defend the Blaine amendments themselves, but they'll give us a run for our money in other areas in the political arena, if that makes sense. It's sort of a shifting of tactics for them.
Definitely. So what are the chances post-Espinoza that Catholic churches or subsidiaries like social service organizations could establish non-religious charter schools? Has that been possible up until now? And is that something that is made possible by this decision? Anybody want to take that, David?
So our view is that having like a religious charter school is not going to be constitutionally permissible, because charter schools are public schools, they're government schools, and in government schools, government institutions, you can't have something that privileges one religion over another. We know that was a concern, a criticism really, that was raised by Justice Breyer in his dissent. But we frankly have a hard time seeing how something like that would be constitutionally viable, though I'm open to being persuaded that it is.
Yeah, and Jeannie, I'll make one step towards trying to convince David, but I'll also sort of say that the problem. It's a very natural question, but if there's a problem with the question, it's only that what's a charter school? I mean that's something that that certainly there's no constitutional conception of what's a charter school, and I guess what I would say is I think David's answer, which is kind of the way I think. Kind of the first cut that most of us would take at it is to say, well, since a charter school is by definition a public school, the public school itself can't be kind of run by a religious entity or can't be kind of religious.
Right.
But, all of the school choices cases teach us that there's kind of a continuum here. And if the state provides just the funds and they provide the funds, based on parental choice, but, they can send the funds to the private school as long as they only go there because of parental choice. There's a point on the continuum where if a state wanted to establish a program where the charter schools were really so different from the other public schools that all the state was doing was providing sort of a format for these innovative schools to then say the one kind of innovation that these schools that are already, one or two standard deviations away from our sort of typical public schools, the one thing they can't do that's innovative is have anything to do with religion. I think then you start to see where you could extend this doctrine and say, no, at a certain point, if you set something up in a way, the whole point of which is to try to get away from the traditional public school model, you can't impose a requirement that says, hey, whatever else you do, don't let any of that religion in here. Because that really, I think, replicates the problem that the court has perceived in Trinity Lutheran and in Espinosa.
All right, well, that's going to be a good continuing discussion because I know there is a lot of interest out there in it. So thank you for that, Paul. Great question from Ben DeGrow. How much hope should states with neutral Blaine Amendment language like Michigan have in finding a path to Supreme Court victory? And how hard would it be to prove anti-religious, anti-Catholic animus without that specific stuff in that language in the Constitution? I'd also add to that, by the way, and we had Paul look at Massachusetts, which people in Massachusetts tend to also think that it's never going to happen there. So what do you think, Michigan, Massachusetts, what about the neutrality of their Blaine as a challenge?
So, all of these are going to depend a little bit on the specifics, not just of the kind of text, but also of the underlying historical record. And so there's really no substitute for kind of really kicking the tires on all of that. But, I guess as a first cut, I would take, some issue with the idea that there is such a thing as a quote unquote neutral Blaine amendment. In the sense that if it's really a Blaine amendment, and then it's not neutral, and it might have some makeup on it to make it look more neutral, but it probably isn't. And one thing, for example, there's litigation going on in South Carolina, and so that's something I'm a little familiar with. And there they had for a number of years they had a kind of straight up Blaine amendment. And then at a certain point, they, amended part of it to say, well, sectarian or non-sectarian. And that's the way they tried to neutralize it. But one of the points that the Supreme Court has made, and Justice Thomas made this point emphatically over a decade ago, is that sectarian itself is a pejorative term. And so an amendment that talks about sectarian or non-sectarian is not really neutral. It's already using sort of language that's inherently problematic. So I guess what I'd say is, I can't tell you that all of those Michigan and Massachusetts amendments will eventually be struck down by the Supreme Court of the United States, but I certainly think that there is enough sort of skepticism in the Supreme Court about the Blaine amendments that I wouldn't sort of start with the proposition that just because they have been made facially neutral, that they're not problematic.
And just to clarify also, if you challenge, if you enact a program in, say, Massachusetts, Michigan, wherever, that is considered currently against their Blaine Amendment, they don't have to go all the way to the Supreme Court unless someone challenges it, right? It could be that the path is open through attorneys general's advisement or through just acceptance by the state courts, right, David?
Yeah, that is true. There are a lot of different ways of getting there. Some of these provisions that intersect with the First Amendment, obviously can be heard in federal court or state court for that matter. But some of them are purely state law questions that they can go after, that way. One thing that I just wanted to add about Michigan and Massachusetts, that one of the things that makes Michigan such a vexing state is that they actually ban all forms of public support of all non-public schools. So it's not simply just singling out the religious schools or denominational or sectarian. And that's one of the things that makes a state like Michigan so vexing. But I do think that there might be hope for a state like Massachusetts, where, that's actually where the Know Nothing Party was founded. And there's actually like a very long and pretty sordid history there. So if we went on the argument that the reason for a law passing having basically illegitimate and anti-religious, anti-sectarian reasons, Massachusetts might actually be more favorable, which is not something that we were even thinking about just a year ago.
Right. Ross, do you want to take a shot at answering a couple of the questions about how to go about implementing these? There's several questions about, where would you start? How do you get parents engaged in states like California? What do you do when there's a majority of the legislature that is sympathetic to opponents' arguments against school choice? And also beyond vouchers, how can even broader choice efforts be established? So maybe Ross and Pam, like ESAs and things like that, can tackle those.
Yeah, sure. I'll take a shot at it, and then Pam can jump in as well. It varies so widely by state that it's tough to put a single answer on that, right? But I think in general, the very first place that you need to start is by getting a sense of your political reality, right? And sometimes it's hard for us because I think we're all fairly optimistic people to look at it and say, man, it's just not going to work in the legislature this year, and we need to find an alternate route. And I think Pam was getting at that earlier. Sometimes you run into a situation like Colorado's legislature where it is so tight that you're going to have to be creative. And maybe that's a school board solution. Maybe that's a municipal level solution. Maybe it's a county level solution. I think there are a host of local level policies that nobody in the country has really contemplated or seriously tried yet that could potentially get you to the same endpoint if you're creative enough about building those out. From a political standpoint, though, if you believe that you do have a shot, or even if you think that you might have a shot, going ahead and thinking through how to build out work and organization around those bills, the first place you always start with any of this is policy, right? So the kind of nerdy work of actually sitting down and building out the policy. I do a lot of that. I know IJ certainly does a lot of that. So does Independence Institute. Getting a really solid school choice policy that makes sense to people that you can sell publicly is the best place to start. Sometimes that is an ESA. I know they're very popular right now. Sometimes, though, the big complicated ESA doesn't work out for you, like was the case for us in Arkansas this year. And a simpler 7-page, super simple bill that people can really grab onto and understand easily is the ticket. So coming up with the right policy is the right way to go. And then beyond that, getting a sense of demand. So anytime ACE goes into a new market, we're looking at how many private schools are there, how many would participate, how many kids can we reasonably serve, and how many kids do we think are out there who need help, who we can't serve. And that latter group is really sort of your army. If you can find a way to tap into those private schools and the private school communities, and specifically the parents who are not getting the help that they need, and sort of start organizing around that, you will find a lot of incredibly talented, incredibly well-spoken, and very, very passionate people who will be much better emissaries than we will, right? So a lot of people on this call are sort of insiders and politicos. We show up and we say things to legislators that we've probably known for a few years, and they sort of pat you on the head and say, that's nice, and send you on your way. It's a lot different when you have 2 or 3 private schools and, a couple dozen parents from inside their legislative district come to them and say, hey, we really want you to move on the school choice issue. We've spent some time thinking about what that policy would look like, and here it is. Here's what we would like you to do. there's a lot more that goes into it, right? We can go pretty far down that rabbit hole in terms of what legislative work actually entails. But starting with good policy and then having the right people out front, which in this case would be schools and parents to really lead those charges, that's the best place to start. And from there, you just really don't know where it's going to take you, but that's where I would start.
And Pam, was it unusual, do you think, or did you see a lot of parents recognizing this issue for the first time because of COVID?
Oh, well, yes, of course. Parents are very concerned. I think that that's going to stimulate some more interest in school choice. But I would like to mention the way that Trinity Lutheran and Espinoza can impact other things besides just school choice. And in Colorado, there's a broad bipartisan coalition to put something on the ballot this year, which is, and in Colorado, citizens can do that. And it's an ESA for out of school learning, so that parents will have access to tutoring or maybe music classes for their children. Well, because of Espinoza and Trinity Lutheran, if a Catholic school wants to offer tutoring, they'll be able to be a part of the program. That's not the intent of the program, to bring in religious schools, but it's a consequence. It's a good consequence of both of those cases.
That's super helpful. Thank you for that, Pam. And I know there's just a couple of other quick questions, and if people have to go, please know that, except for my panelists, I'm going to keep you for a few minutes, that this will be posted online in a couple of days, as well as on CER's Reality Check podcast. But another question about states that have or can enact school choice program. Would it be really difficult, and how difficult under Espinoza, for legislation to include mandates that make it impractical for private religious schools to participate? And I think where Mr. Schaefer is going with that question is, can they put all sorts of poison pills? Private schools say, forget it anyway, I don't want to participate. Pam, have you seen that as a trend? And Ross and David?
Well, in Colorado back in 2003, there were private schools concerned about that. So yeah, you have to be very careful. Always,
right?
Yeah, and we certainly have seen a lot of that both this year and in previous years. And sometimes those are overt provisions that are obviously meant to get around Blaine by saying, hey, you can participate, but you can't have religious iconography in the room. You can't read the Bible. You need to segregate your instruction from any kind of religious curricula. Sometimes they look like that. Sometimes they're just very heavy regulations on the school. So you need to be accredited by this specific body. You have to let your students in on the basis of a lottery. You can't screen kids on the way in. They have to take state tests. I mean, all sorts of things that make life very, very difficult and very expensive on private schools with that intent, right? They always frame it as we want accountability and quality. The truth is they really would rather not have those schools participating. And unfortunately, if you're not very vigilant with the policy, that works. We've seen that play out in Louisiana in a big way with their voucher program, where if you over-regulate that thing, most of the good providers who don't need the money that badly say, no, thanks, your money's too expensive. And you get left with a pool of providers who really desperately need the money and tend to be a little bit less stable, which of course translates to results for kids that are not what we would hope for from a school choice program. So that's absolutely a thing. As far as how easy it is, that really depends on how closely you are watching that sausage as it's being made inside the Capitol, to be honest with you. It could be very, very easy, right. Or preferably it would be very, very hard for them to pull something like that off.
Right. Is there also an issue of publicly funded versus government controlled, and a consideration whether the choice could be considered a government actor? David, Paul?
Yeah, I mean, that's more of like a legal question. So a lot of different courts have adopted what we call the child benefit theory. And so basically this is just the kind of distinction between, who is this benefit for? Is the benefit for the school, or is the benefit for the student? We think it's for the student. For example, in different contexts, if you're providing a food stamp, is the benefit for the needy family, or is it for the supermarket? Of course, it's for the needy family. Unfortunately, not every state court has adopted the child benefit theory, despite it being persuasive to the U.S. Supreme Court. But we think that it's eminently persuasive, and we work hard in all of our cases where it's at issue to just drive that point home for them.
Anybody else have thoughts about that? What about sort of last question, just to kind of wrap it up, and then I would just love some closing thoughts. And I don't know if anybody got to see the poll that we popped up before, but it's always exciting to know that some people are just learning about this issue this week, this year. And so it's kind of that 70 to 80% rule that we see a lot of people know about it, but there's always a few, and more than a few that don't. And so I'm very happy that we've been able to help educate and inform about this issue. So final quick question for all of you, and I would love just kind of a recap or any last thoughts. As you think about the questions that you've heard, as you think about the challenges out there, whether it's political or not, and it crosses lots and lots of different issues. Are there any issues that have not come up that you think are particularly important from a legal standpoint or legislative standpoint that could help encourage or inform policymakers about this issue? I mean, Blaine, again, is still kind of an archaic idea, the fact that this exists, but are there any things that haven't been mentioned that you think are important to raise, and any places that you've seen where there's a complete curveball shown? Or do you think this is pretty straightforward going forward? Let me go ahead and start with David, and with David, Paul, Pam, and we'll end with Ross.
Sure. My answer is probably a little bit counterintuitive, and that's that, as attorneys, we spend, our time poring over very esoteric and hard to read and at times annoying texts, try to make the most persuasive argument we find, and then we make it. We argue it to other lawyers, and when we tell laypersons about it, they have trouble understanding us. We just have to trust us. This is how it works. And because of that, I think of the rules of persuasion, which is that most people are persuaded emotionally first before they're persuaded intellectually. So when you're talking to a legislator or someone who's skeptical of school choice, it's helpful to have someone who would actually benefit from school choice talk to them first. Like, why do they need this? Are they indigent? Is their child being bullied in school? Are they suffering for some kind of reason? Because that's the way to convince someone. The legal arguments are good for the people who are either neutral or who are already persuaded of the justice of our cause. But by bringing in the people who it's really impacting, we're keeping our eye on the ball, and we're really opening up hearts and minds to what it is that we're all trying to accomplish.
Thank you so much, David.
So, I would just, add that from two points. One's more legal, one's a little bit more, I suppose, political, which isn't really my expertise, but I'll throw it out anyways. On the legal thing, I think on the legal issue, it's actually the challenge of our side of this debate to keep it simple, because the principle that emerges from Espinoza is not complicated. It's that, if the state wants to have a program to promote education, it can't discriminate on the basis of religion. And, it really is that simple. I mean, obviously, the more specific way of putting it is if you're going to include private schools in the program, then you can't discriminate on the basis of religion. But I really think the broad principle here is, we're done with this idea that we're going to be able to discriminate against religious schools just because, we have concerns under our own state constitution that we don't want to establish religion. And that's essentially the argument that the Supreme Court's heard for, decades now, that, states are saying, well, we need to discriminate on the basis of religion in order to avoid an establishment violation under our own state constitution. And that's really the argument that I think the Supreme Court has signaled that it's tired of hearing and is not going to accept. So just don't discriminate. I think it's that simple. On the political point, I would just say that, I do think the pandemic is a real game changer here. And, one of the things that, I think that jurisdictions that already had a degree of choice could really kind of benefit from was having a model out there that was different. And it allowed people to sort of, test in real time the claims that were being made by the public schools, because you had this nice comparator out there. And obviously, just by having private schools, you had some of that comparator. But I think, choice programs really, and as the pandemic showed, it's having choice and having a diversity of options has its own benefits. And I think it is hard to make the contrary argument.
Thank you very much, Paul. Don't discriminate. I think that's good counsel. Pam.
Well, I would just like to give advice to states that don't have that are having trouble maybe passing a private school choice program. If you don't have a robust public school choice program, that is a route you might be able to, make some ground on. Colorado, since the early 90s, has had open enrollment to the point of, and it's very open enrollment, where parents can send their children to any school in the state, any public school in the state, as long as there's space available. It meets the criteria for the child. But your public needs to get used to the idea of choice, and that I can choose a school in another district. And we have a school choice for kids website that helps parents find public and private schools in Spanish and English. And we do all sorts of things to just try to help the public understand, accept, appreciate choice, so that hopefully they will then say, hey, why can't I go to the Lutheran school down the street? I hear from my neighbor that they're really good. So I think you have to educate your public in that way.
Thank you, Pam. Finally, Ross, last words.
Yeah, so I'll say two things on the way out. The first one is that I think even with the Espinoza win in the bag, everybody needs to still be aware of other legal challenges potentially, right? So we've got states that still have compelled support provisions on the books. Sometimes they have strange constitutional provisions related to how they fund their public schools and where that money comes from. And so there's always sort of the possibility that you're going to see the other side do what I call the spaghetti noodle approach, where they just throw a bowl of stuff against the wall and file 18 challenges just to see what sticks, right? So even though it's good and totally warranted to bask in the glory of the Espinoza decision, we also want to spend some time thinking about, are there other places where we could strengthen these legislative proposals or these programs from a legal perspective, so that we can save ourselves some headaches later on down the road with new challenges when they do figure those out. And then beyond that, I'll just circle back to what I said initially, which is that, now that they've lost the ability to sort of do the finesse approach with Blaine amendments and the separation of church and state, they really are shifting to some pretty hard politics. And I saw a lot of that this year in the work that we did. I know David did as well. And they're going to continue that. I think now that they realize that leg of the stool has been knocked out and that their options are limited for taking these programs out after they are passed, they're going to start really shoring up what they can do, both in terms of elections, in terms of legislative control, in terms of general political power. There's going to be a lot of that. And honestly, the folks who are on our side who would really like to see choice expanded for kids, we need to spend time building that kind of infrastructure as well, right? So it's not good enough to rest on our laurels. We're going to have to make peace with the fact that the game is the game and always has been the game, and we're going to have to play it. So certainly we'll be spending a lot of time at ACE building that out and being ready for the next big knockdown drag out that we have in the state legislature. But my encouragement would be to keep building for it, because we know that they will be there and they'll be building in the meantime.
Thank you all so much. And, when you just think everything's sort of behind us and there's more to be done ahead with this decision, you think about, and one of our participants pointed out how so many parents and families are already opting out of the traditional system. So I think the pandemic also opened up an entree to all sorts of new kinds of schooling, education opportunities that may very well also be challenged, whether they can be borne by, supported by, or undermined by an Espinoza or a Blaine remains to be seen. But I think the most important thing, I think, to leave everybody with, on top of how important this information is and to get it in the hands of people who know, is that opportunity comes in lots of different ways and shapes. And that's what we're all here for. So thank you all for taking the time, spending a little extra time with us out of your busy days. We'll make sure that everyone who has attended and who's watching after the fact has important contact information and can access all of your resources. Don't forget to go to edreform.com/choicesconstitutional. We will be happy to help also answer your questions and put you in touch with the experts. Thanks again to our guests. Appreciate it. Have a great rest of your day.